All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for 2025 Legislative Roundup, Key Consumer, Housing, and Access to Justice updates. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you registered, you're going to receive an email from Zoom with the link to the recording, the materials, and the CLE code. We will also post it on YouTube so you can have access to it if you were unable to register. The training was approved by the Florida Bar for one general CLE, zero point 0.5 technology CLE, and one state and federal government and admin practice certification credits. I'll announce the CLE code towards the end of the presentation. I will drop it into the chat. It will also be included in the email that goes out from Zoom. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. I also wanted to remind you that this training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. So if you're not familiar with PILS, I'm going to drop the link to their website on the chat. One of the work groups that I participate a lot is the Consumer and Tenant Protection Work Group, and that's one of the topics that we'll be discussing today. So if you're interested in this type of discussion, I highly encourage you to join PILS. And final piece of housekeeping announcements are questions and answers. During this presentation, we're going to have multiple topics, so please use the Q&A. We disabled the chat to try to keep limit use to the Q&A. You have access to that in your Zoom toolbar. So we will also try to reserve some time for questions towards the end. So if the questions that come in are related to the topic, I'll make sure those are addressed as we are discussing. So for purposes of time, I'm going to go straight to introducing our speakers quickly. I have their full bios and the materials that I'll share. Today we have with us Kevin.rabin. He is the Consumer Advocacy Project Director at Florida Legal Services. And we have Nicole.avila, who is the Supervising Attorney at the Survivor Advocacy Project at Florida Legal Services. So before I pass it off to Kevin and Nicole, I'm going to launch a random poll. And I want everybody to look at their phones, or if you have like particularly your personal phone, your personal email. And I want you to tell me how many unread emails do you currently have. So just going to launch the poll. I'm going to look at mine, and I currently have, and I'm one of those serial email people. I'm going to let you know how many I have. So right now I have 44 unread emails. Kevin, how many unread emails do you currently have?
I am what I call a very insane person. I have zero in both my work and personal email inboxes.
Nicole, the pressure is on you. Tell us how many unread emails?
Let's see. I know it's way over 1,000 on my personal for sure. Let's see.
We see some of the answers come in. I
Mine
don't
just
know if
says
I
like
added
99 plus, you know? That's
90. Okay, so that may be over 1,000. I see we have five people actually pled the fifth here in the polls. I'm going to end the poll and share the results, but it's kind of funny that we have a little bit of it's a little bit all over the place. So let me go ahead and share the results with everybody. Hopefully people can see these, but it seems like we have about 23 people, that's 34%, that are 0 to 10. They're similar to Kevin, where they seem to be checking their emails and not a lot of them are unread. But Nicole, you're not alone. We have 12 people
yeah.
that answered 1,000 or more. So you're not alone here. And you will see I bring this question up on unread emails because it's actually going to be relevant to some of the bills that we're going to be discussing today. So I'm going to stop sharing the results, and I'm going to pass it over to Kevin and Nicole. The floor is yours.
Thanks, Jorge. Again, Kevin.rabin with Florida Legal Services. Happy to be presenting on this topic regarding legislative roundup. We're going to be covering a set of bills that came up in the past session and have now been codified in Florida statutes. And I'm glad Jorge did his icebreaker regarding emails, because several of these regard the shift from physical delivery of notices or delivery by mail to email delivery. So I didn't think there would be that many of us who are like me that are zero inbox sickos, but honestly, we're probably in the better shape for this change. For those who have a lot of unread email, some of these changes may not be the ones that have you in mind. And so I think there may be some adaptation necessary as we go forward. So today's legislative rundown, we're really going to cover 6 critical bills that were proposed in both the House and Senate and ultimately passed and codified. At the end, we're also going to talk about a slew of upcoming bills that have been proposed for the upcoming 2026 legislative session. It is pretty active in proposals. Not all of these are going to make any headway. Many of them will die before they even get their first look at committee. But some of them have co-sponsors, some of them have Republican and Democratic sponsors, and some have what are called companion bills, one in both the House and the Senate. And that means that they're more likely to have a chance to move forward. So starting down, we're going to be starting with the debt communications bill that was passed, electronic delivery of notices by landlords and tenants, advertisements for representation services, or what we like to call a bill targeted at the notario problem, public lodging and transient occupancy, property rights specifically focused on what is called commercial squatting, vexatious litigants, and then those upcoming bills that we discussed. So what we're focused on today is really the top level of information. I don't want to spend too much time really going over the text of the statutes because we'd be really looking at it at a microscopic level at that point. And a lot of these changes were fairly incremental instead of landscape shifting. So they're important changes and they're going to have a big effect on the work that many of us do in public interest law. But I want everyone to focus on these top level highlights because a lot of these bills are going to be the subject of future litigation over the next couple of years. We'll also talk about some of the possibilities and a couple of bills where there was an amendment, in particular regarding the Florida Consumer Collection Practices Act, that was defeated. And I think we want to focus on why looking at some of these amendments and keeping track of legislation is so critical to help prevent worse pieces of legislation from emerging. So we'll start there with SB 232 and House Bill 417. This was a pair of bills proposed to amend the Florida Consumer Collection Practices Act, so dealing with debt collection. There were two notable changes that were made at the end of this process. The original bill was targeting these changes, and this is ultimately what passed the Florida legislature and was signed by the governor into law. This amended the prohibited practices section of the Florida Consumer Collection Practices Act, section 559.72. And the two changes were first that the language in the prohibitions was softened from a mandatory no person shall do these listed activities. Was a total list of, I think, 18 prohibited categories to a person may not. As again, whenever you shift from a shall to a may, the legislature is changing the way that courts will interpret that text from a mandatory condition over which the court has no discretion to excuse a prohibited behavior to one where the court has a little bit more discretionary function. And I think that that was a change that we probably could not have prevented, no matter how much lobbying we may have been interested in doing. But it is a notable one that will come up more in cases that are brought under this law over the next couple of years. The other amendment was to subsection 17. This dealt with the time of communications with a debtor by any person collecting a consumer debt. And specifically, it was amended to exempt email communications from this time limit. The time limit restricts communications in the overnight hours, but a series of lawsuits have been brought specifically in federal court regarding emails that were sent by an automated email system to collect debts at like 12 p.m., 1 a.m., or 12 a.m. rather, 1 a.m., 2 a.m. The recipient would maybe read and review it in the morning, but the time when it was sent was within the original temporal limit. And so these cases involved a lot of interpretation of whether this really was a violation of the statute. Most of those cases came down on no because it focused on when the recipient actually read the communication. That's the time in which the violation would have matured. However, the industry that was being attacked apparently was the storage industry. The self-storage business sector was really interested in getting this amendment to help just completely foreclose these challenges. And so ultimately, that was the way the legislature went and adopted a bill creating this specific exemption to say that email communications in these restricted hours don't count. So part of why I want to highlight this change, though, is those are pretty minor changes. What got defeated was a much more significant change. And again, this is to specifically highlight the efforts of the Florida members of the National Association of Consumer Advocates and of Jacksonville Area Legal Aid to help muster the energy to defeat this specific amendment in committee. So this amendment, as you can see from the excerpt that's down below in the presentation, would have changed the definition of the covered entity under the Florida Consumer Collection Practices Act from any person, which under Florida law is literally any human being or any business that is collecting a consumer debt, to a debt collector. A debt collector is specifically defined as an entity that's collecting a debt on behalf of another or is in the regular business of collecting debts. That is a much more limited application of the statute and would have effectively changed our much more broad consumer protection statute into a mirror of the Federal Fair Debt Collection Practices Act. This would have significantly limited coverage and would have foreclosed a lot of the efforts that consumer advocates the state overuse to help ensure that the statute has teeth and protects a lot of consumers from illegal collection practices. Particularly for anyone who does landlord-tenant litigation, this would have completely eliminated most efforts to go after property management companies who are acting as the landlord. So thankfully, this was defeated in committee by vote, which is extremely rare. Most of the time, if a sponsor to an amendment senses the amendment is not going to fly, they will pull it. Senator Rodriguez, for whatever reason, allowed it to go to vote, and it got defeated unanimously. So it was a huge victory and an example of what good consumer advocacy can do in the legislature, bringing good stories to help defeat a potentially toxic amendment. But I also wanted to highlight this because there's always the possibility that this kind of amendment could be brought back again, right? We already saw the softening of that language about, shall to may. I think it's pretty likely that this kind of language could be presented again in the event of future, other subtle tweaks to the Florida Consumer Collection Practices Act. So next we'll move to SB 1164, HB 615, and this was another pretty big shift for the electronic delivery of notices in landlord and tenant relationships. So this statute is a whole new section, 83.505. And what it did is created an option for landlords and tenants through a lease addendum that is in a substantially similar form to the statutory form that's now created to opt into email communications of all required notices required by Florida statute or by the rental agreement itself. So the first subsection says that there's a specific set of conditions you have to meet in order to create this option. 1, there has to be a signed addendum to the rental agreement. 2, there has to be a valid email address for receiving the notices. 3, the addendum has to expressly state that it's voluntary, it can be revoked by either party, and either party can update their email address at any time. There's some effects and problems though, right? Anyone who's ever dealt with email knows valid email addresses are always a problem. If somebody mistypes or misenters even a single letter or extra digit, you're going to get bounce backs. You're going to get, issues with ensuring delivery of that email. And the statute doesn't really reckon with what to do if you have validity issues that emerge. It also doesn't really talk about what to do with non-responsive emails or ones that are not maintained actively by either the landlord or the tenant. And obviously, with a lot of the timing of tenant-specific notices, like a 3-day notice for non-payment of rent sent by a landlord to a tenant, the time limit is really important. And so if that notice is sent, say, tactically at 11:59 p.m. on tonight, October 27th, the tenant may receive it that same day, but may not even notice it or check it until the next day or a couple days later, at which time the time period may have already elapsed for them to pay the money that is required by law. So it's going to be important to keep an eye on how tenants react to this and whether they agree to these additional addenda. There's another couple subsections to keep in mind. 1, it can be revoked at any time based on the delivery of written notice to the other party. But there are some issues with the vagaries of how you demonstrate proof of delivery and whether either party could try to game the process. For example, a scenario I envision is that a landlord could send an 8349 disposition of security deposit notice to a tenant via email, and then immediately with it send a revocation of email notice. Therefore, the tenant would have to send an objection in writing to the landlord at a separate address and could not respond to that same email with their written objection that the statute provides. So there's potentially some opportunities for gamesmanship in there that I would fully expect landlords to use if they've gotten the signed addenda in order to use email notice. The other thing is also there's a requirement for the sender of any email notice to maintain a copy of the notice sent electronically and evidence of the transmission of the email. The big issue I get here is in cases in which our clients say they never got the email, it will be very difficult in litigation to obtain copies of those documents because under summary procedure, we have no guaranteed right to written discovery. So normally a request for production would be the method to send it out and get a copy of the documents that they saved. You'd have to ask the court for leave in order to get that request for production served upon the other party. There's also issues with the possible fabrication of these documents that are created specifically for the purpose of ensuring compliance with litigation, yet were never actually sent. There's a lot of questions, I think, that are going to emerge in litigation very early on regarding this specific issue of preservation of notices sent. And certainly for tenants, this will be difficult. If a tenant has opted into email notices and sends a rent withholding letter, whether they maintain the copy of their communication can be a big issue if they try to raise that defense but don't maintain that document. The other side may move to strike if they don't attach copy of the email, delivery mechanism. There could be a lot of issues that will come up with the specific use of email communications. So again, the other thing is it also isn't preclusive. I mean, my advice to most tenants would be unless you are one of these zero inbox people like myself, don't opt into this. Written notices are always safer. And to some degree, you always have an easier time forcing the hand of the other side to prove service when it was required to be done in person or when it was required to be done by mail. It is a heavier burden for them to prove and heavier burden for them to fabricate evidence of delivery. So just briefly, I wanted to show a sample of this. This is courtesy of Jorge. I believe this may have been the NAA addendum to lease agreement he got in his own personal life. So he has redacted all sensitive information. We don't know if that is him or not. But this is the industry form that's already been developed by the National Apartment Association and the Florida Apartment Association for use. And I would expect that for many tenants, this will be in the big old giant electronic signature packet for tenant lease forms that they will receive. So I think it's important to just get an early look that it does seem to comply largely with the new subsection. I didn't see anything in here that seemed to go above and beyond what that section clearly requires. But I think everyone should be on the lookout that we're going to start seeing these new addendums show up in lease packets that our clients bring to our attention. So for the next slide, I'll pass it to Nicole to talk a little bit more about Florida's attempt to solve the notario problem.
Thank you, Kevin. So by way of background, in many Latin American countries, a notario or a notary public is also necessarily an attorney. Only attorneys can be notary publics in many places in Latin America, which is obviously not the case in the United States. And so for many folks, that are seeking immigration assistance or form preparation and other either immigration, I see a lot of them also family law form preparation and things like that. When they're advertised as a notario, typically folks will just assume that that's probably somebody who's licensed as an attorney or in a way that they're allowed to provide some sort of legal representation. And so Florida is attempting to curb this. It is a massive problem throughout the state, particularly for immigration cases. So it prohibits folks from translating notary public into whatever language their advertisement is in. It also prohibits them from saying that they have any sort of expertise as an immigration consultant, immigration assistant, specialist, or anything like that for folks that are not authorized to represent people in immigration matters. The pool of people who are authorized is very small because that authorization or certification is or accreditation, I'm sorry, is provided by the Department of Justice through the Executive Office for Immigration Review, and it's available for certain folks that work in nonprofits, and that accreditation stays with the nonprofit. It does not travel with the person who is accredited. So anyone who was previously accredited and now is working independently or with a firm of some sort that is no longer in a nonprofit is no longer authorized to do that. It also created a cause of action against the person who does advertise in a way that is not allowed by the statute for declaratory relief, injunctive relief, damages, and attorney's fees and costs. And it also created a new statute that requires them to post a conspicuous notice that states that they are not an attorney, they cannot provide legal advice, they cannot represent people in immigration matters. And hopefully we haven't really seen this in practice too much yet, but hopefully it will help curb the issue with folks that have been victims of notario fraud. And so the statute gives relief by way of tort action so that folks can get some monetary relief after the fact. It's very difficult, or it was very difficult up until now, even when it was reported through the AG's office or the Florida bar. Hopefully it will be deterrent. There are no punitive damages in the statute. And there's no per se irreparable harm for injunctive relief purposes. It is, of course, only a small piece of the puzzle for immigrants. So, especially given the current climate and the current enforcement policies throughout the state, it's very important that folks are accessing the right help for immigration so that they don't land in a more precarious position. So hopefully this will be a deterrent. The statutes, we have a question that whether this also affects notarios offering services for divorce, loan modifications, etc. So it specifically talks about immigration preparers or immigration. Give me 1 second. I have it up so I can tell you exactly what it says. So it specifically says that they may not give legal advice. So if they're doing any advertisement, it has to state, I am not an attorney licensed to practice law in the state of Florida, and I may not give legal advice or accept fees for legal advice. And it has to be in the language of the advertisement that they're doing. So if that's in a language other than English. As for it doesn't state anything specific to immigration matters or to other matters other than immigration, other than they are not allowed to use public notario público, notario, or any other immigration assistant, immigration consultant, and things like that. Kevin.
Yeah, just so the FDUTPA section, or the Florida Deceptive and Unfair Trade Practices Act, section 501.1391, that one is really exclusively focused on the offering of immigration services. However, the definition that was modified in 1117.05 specifically makes this a categorical requirement that they disclose that they are not able to offer legal advice or services. And I think to this extent, you just get into, like, I think a smell test that if it looks like the unlicensed practice of law, then this disclosure requirement, any of that unlicensed practice of law that would violate that disclosure requirement would be actionable under the other new statute 117.051. But again, it would require a showing that the person was actually harmed, or if they've been put in a position that's detrimental because of the advice given. Obviously, the Florida bar is always in a position to punish the unlicensed practice of the law, notwithstanding these statutory provisions. But this should give us as advocates an additional opportunity to not just refer them to a process we have no control over, that we have no ability to influence, that at the end of the day, they have at least some court representation option available to them. And again, I think because the statute kind of lacks some of the more, we'll call it some of the higher grade of teeth, I would expect there's not going to be a lot of pushback from courts if you're kind of pushing the limit of its enforceability, because again, it's focused mostly on the public harms and the injunctive relief that can be given in these cases. So I would at least push that that first piece when the modifications to the notary public limitations, because I think that fits more with what the legislature was targeting here.
Mhm.
Right. So the next couple bills are kind of a theme, so I'll talk about them briefly. SB 606 and HB 535 were to effectively modify the definition of transient occupancy when it relates to public lodging establishments. So this is mostly things like motels, hotels, vacation rentals, bed and breakfasts, and timeshares. And for a long time in Florida, we had this presumption of transience if this was not a person's single exclusive residence. But there was a whole list of factors you used to determine whether this was a person's primary residence. However, the legislature, after years of property owners complaining that they just had to go to court to do something, and that was just too expensive and time consuming to actually determine what people's rights were, the legislature finally buckled and gave them an easy out, which is that now transience is presumed when there is not a written rental agreement that designates the dwelling unit as the person's sole residence, which is a huge burden because almost none of these entities are going to give a written rental agreement that designates that this is the person's sole residence. That's just not the business they run. And what effectively it's trying to target is a crackdown on a lot of month to month leases for people who kind of live at the fringe of formal tenancy, that were living in motels and hotels and living there for years. Living there as residential tenants that ordinarily should be subject to the eviction protections of Chapter 83, Part 2. It instead set out a way for them to use a non-court process to remove those people at the whims of the sheriff's office. The other aspect of amending this was to take away a subject of litigation for years. Back in 2015, this issue came up in Central Florida because sheriff's offices were refusing to arrest people who were allegedly overstaying their residency at hotels and motels. And the federal court charged with that case ultimately agreed that it was in the discretion of the sheriff's office to determine whether a criminal offense had been committed, that there was no automatic ability to force them to arrest people who had overstayed because those people may be actual tenants and not transient occupants. The modification to the statute, though, now gives the sheriff a mandatory removal power and restricts the arrest power only to when the sheriff feels it's warranted. So at this point, it is in line with what we're going to talk about with commercial squatting, but this kind of follows after last year's modifications to the unlawful detainer statute, Chapter 82, to create a non-court process for removing people from residential rental dwellings without any eviction process or protection. And so I think this is right in line with that same protection. It is a crackdown against people who live in non-formal tenancies. And so I think it's definitely going to be a huge aspect of shifting our focus. A lot of it, I think, is going to be on trying to find any written evidence that would constitute proof that this person did use this as their sole residence. But this change is going to make it significantly harder to assist many Floridians who live in motels or hotels as their primary residence. So I mentioned the commercial squatting and that they're of a kin. That's because they are. I mentioned earlier the unlawful detainer statute was amended last year to create this new process for filing an affidavit with the sheriff's office to remove a person who's allegedly unlawfully occupying residential real property. Apparently, they didn't like that there was this possible gray area for commercial property where it was zoned commercial or the person might be squatting in a dwelling that's not a residential dwelling. So they've just foreclosed that gap by now authorizing the same exact procedure for commercial properties. They also made a small amendment to the affidavit form that is to be used with the sheriff's office that authorizes the sheriff to enter the property using reasonably necessary force, search the property, and remove any unauthorized persons from the property. When you consider the other things that are going on, this is, I think, a pretty clear indication that our legislature is blessing more and more ambitious attempts to enter property and take custody of people who may or may not be there with lawful status. So I would expect that you will see more of this kind of entreaty. I think you'll see more of property owners using this as a way not of trying to actually remove quote unquote squatters, but removing people who they have entered into quasi legal transactions with in order to just cut off their access to court procedures and protections to avoid a wrongful deprivation. I guess the silver lining here is that just like with the wrongful removal provision, there is also a statutory remedy now for wrongful removal from commercial property that is the same as the one from residential property. So unfortunately, this is of just a growing movement towards using a non-judicial process to remove people from property and eliminate their property rights without due process. I'm unaware of any big constitutional challenges that have been posed to these so far, but I do think that there are significant ones because there just is an insufficient guardrail against wrongful deprivations. So I think Nicole and I will tag team here on the last big legislative change because I think it covers pretty much everyone in the state with your civil litigation now. For those who are unfamiliar with what a vexatious litigant is, SB 1650 HB 1559 sought to address a longstanding problem, or at least perceived problem in Florida courts, which is that many self-represented litigants don't file cases for any legitimate reason, but rather as a measure of fighting back against perceived injustice, whether that is in a court case that was decided against them, or because they're just trying to punish the court system for some perceived slight, or they're just trying to harass the other litigants involved in the process. There are many people who do actively misuse our court process for illegitimate ends. And the word that we've chosen for these people is vexatious litigants. So a couple years ago, the Florida Supreme Court had assembled a work group to discuss and investigate to what extent the current Vexatious Litigant Act, which was codified at 68.093, was effective in deterring truly vexatious litigation, while at the same time ensuring that Floridians had meaningful access to the courts as guaranteed by the Florida Constitution. The work group surveyed primarily trial court and appellate court judges to understand the scope of the problem as it currently stands. And the survey noted from the trial judges that responded, it was about a quarter of all trial judges and appellate judges that responded to the work group, that most of them estimated about 10% of their workload was dedicated solely to addressing vexatious litigants, which is a meaningful amount. That is a meaningful amount of trial court time that is roped into dealing with people who are not actually trying to litigate cases or try to seek real redress. I can say personally, even though most of my work is representing tenants and consumers, I have run into self-represented litigants who have committed egregious forms of vexatious litigation, and it comes in all forms. Mostly landlords who were unhappy that they didn't get what they had asked for, that believed they were entitled to only what they get asked for, and that the court was supposed to just rubber stamp it for them. And these do take up a lot of time. That specific vexatious litigant I dealt with tracked across, I believe my final count was something like 35 trial courts in the state of Florida, 6 different federal courts, 10 different federal court cases, and at least 4 trips to the 11th Circuit or Supreme Court. When they can freely file, some litigants will take it as far as they possibly can. So prior to July, the rule of thumb was 5 civil actions commenced under the probate rules or the civil rules within 5 years that are determined against you, you can be determined vexatious and barred from filing cases without an attorney licensed to practice law in the state of Florida. However, the work group felt that this was an insufficient solution to the problem. So I'm going to talk about one of the things they did to address that was to increase the time in which we could look back as a court at the amount of litigation a person has engaged in that's been determined against them. And what they opted to do was increase that look back period from 5 years to 7 years. They did keep the 5 or more civil actions that were the focus of attention. There was an original proposal to look at as little as 3. I think thankfully they stuck with 5, which is, I think, a more legitimate litmus test. But they also changed the focus to not just be on the number of original actions filed or commenced, but also the behavior within cases, which would include vexatious litigation in a single case. And so I think there's some of it here in the slides, but I would encourage everyone to take a look at the statutory text because it fully governs all behavior in connection with litigation, whether that's challenging a court's decision against you endlessly, that can now qualify as vexatious litigation. So can filing multiple collateral attempts to attack the underlying determination of that court. And this also can include other types of harassing conduct that has been deemed to be a problem, like serial repeat filings that clog the docket without meaningfully changing or asking for new forms of relief. I'll turn to Nicole to talk about the other big change, which is the scope of what litigation counts.
Thank you so much, Kevin. So where before July, as Kevin mentioned, it was civil actions under the civil rules or probate rules. The change now includes family law rules or small claims rules. So in the context of family law, I think what we anticipate seeing, I think, is a big change on sort of both sides of the V, where we do see many self-represented parties that abuse that use the legal system to continue to perpetrate abuse against their victims. I think it could also potentially have a chilling effect on legitimate claims by survivors. It does, as mentioned in the slide, the possibility of use against folks that are filing injunctions for protection, seeing as how varied the possibility of obtaining that injunction can be under the similar facts across all 67 Florida counties. It is very circuit dependent and very judge dependent. So that is a potential effect, but I think it does give survivors also the potential for some relief, while the cases where I've had one wouldn't have been classified before as a vexatious litigant, not necessarily as vexatious as the one that Kevin mentioned. We've had some in which the abuser has not only filed multiple actions against our client, but also against the judges in multiple venues, interlocutory or what would be potentially interlocutory appeals, and trying to bring in every party from our client to the governor and the president throughout, and continuing to relitigate things that have already been decisions that the court has already made on motions, which would not have been counted before. So I do think it gives survivors an opportunity to have some relief from that, and having the self-represented party either have to pay a bond or have to have their pleadings reviewed by an attorney before they file anything within the court and things like that, once they are found to be a vexatious litigant and placed on the list.
I think there's 2 other big practice tips that come out of the new changes that I would really focus on for all of us to look for. The first is to know that now court can use the determination of vexatiousness by a federal court or another state court. So, for example, somebody who went to Georgia and decided to be a menace and then comes to Florida to be a menace as well, then that person can be reciprocally determined vexatious on the first attempt. And I think that is important. The case that I referenced, the federal bankruptcy court had already barred my vexatious litigant from any bankruptcy filings in the entire United States for 5 years because of serial misrepresentations made regarding their wealth and status. And so, as a result of that, now I can just ask the trial court on its first look, it looks like the same behavior. It has the same final adverse determination against this person. I would ask this court to use that as part of its vexatious determination, and the court is now empowered to make that decision more readily, which should help streamline efforts to hold vexatious litigants accountable. The other thing is now trial courts can do this freely without having to use the administrative judge. This was a weird quirk that the way it was originally designed is the only way you could get a vexatious litigant barred from filing in the court or the circuit was to have the administrative judge make that call and then post this order as part of the court's administrative orders or otherwise published so that everyone else could know. We've kind of streamlined this now to say that any trial court can do so, any appellate court can do so, and they have to send a copy to the Florida Supreme Court's clerk for logging in a public database, which is important because if you run into somebody you think might be vexatious, I would go ahead and look at that website. The clerk's website does make it available to determine the full list. It's not fully updated last I had checked, but the hope is take a look at it because sometimes the courts won't catch on to it. They'll go from litigating in North Florida as a vexatious litigant to suddenly appearing in South Florida for the first time. And the clerks don't do this search on their own. They rely on litigants and attorneys to bring it to their attention. And that's the other end of that tip is any attorney and it's representing a party in the case can raise this issue to the court's attention. So it's important to kind of think through the practical tips if you run into one, but also to be aware of it if your client's coming to you and they maybe seem like they have an axe to grind, it may be because they've already been determined vexatious. And I would expect to see more unfortunate clients who aren't truly vexatious getting caught up in that determination. That's my cynical note there is I think we're going to see more of that, unfortunately. So with the remaining time we have about 18 minutes left here. I'm going to use about half of that to just talk about upcoming bills, because I think this is a big point, focusing not just on what we saw get passed, but what's potentially on the horizon, because we have an early session this year. I've gone ahead and noted that early session does begin on January 13th, and assuming the legislature gets all of its business done, we'll talk about why I think that's highly unlikely this time around, then they should complete on March 13th. So I've also put here the link of how to track bills. I highly suggest everyone keep a page on the bills that they're interested in, because like we talked about in reference to the Florida Consumer Collection Practices Act amendment, it's not just what's proposed, it's what amendments come out regarding these same bills as they go through committee. So I would just make sure to, keep a bookmark on all the bills that you have of interest and update people if you see something concerning. The big thing that the legislature is going to be tackling has been in the news pretty much non-endingly for the last week, and that is real property taxation. So the governor made his big swing. We should eliminate all property taxes in the state of Florida. I personally, and this is simply my personal view, that's an insane statement to make, and it is an insane position to take if you're trying to fund the state of Florida. But there is a big call to revisit how we do property taxation in the state. And I fully expect that the legislature is going to be consumed with a lot of debate and horse trading about how specifically to address the rise in real estate taxation that came along with the increase in property values throughout the state as we've been in this boom period of growth and relocation from other states to our own. So I fully expect that this is going to be a huge issue. There's a lot of other political ramifications involved, including the attack on the home rule power of municipal entities. I mean, that's really, I think, the governor's motivation. But at the end of the day, I think it's important to note that there will be some changes, and it's important to follow, not just for all of our own existences, but I think for our clients too, because this will have huge ramifications on those who have mortgage escrow requirements, or for a lot of our homeowners who are facing property tax sales as an unfortunate consequence of other financial instability. So just a couple other bills we'll touch on briefly. SB 44 proposes the electronic payment of public records fees. Most counties already allow this. Most counties and cities already have a mechanism to pay for any public records request production electronically. This bill would just make it a mandatory requirement. I think that's probably a positive if you've ever had to deal with a public records request. The last thing you want to do is, oh, we need payment by check. That just adds to the delay and the frustration. So hopefully this might make get some ground in committee. There is no companion bill in the House yet, which means it is less likely to pick up traction. A pair of companion bills, HB 185 and SB 78, talk about home hardening products and a tax exemption for them. I note this only because there is always the possibility that when there's a tax exemption that could benefit homeowners from getting these products, there are a bunch of door-to-door solicitors who may show up to try to incentivize people to buy them at inflated rates or in exploitative consumer practices. So if this were to pass, I would just be on the lookout for the possibility that our door-to-door solicitors that do roofing fraud, that do solar and green energy improvements fraud, may also start offering garage doors and other forms of home hardening products in a similar fashion. SB 120 is a really weird bill. It would include contract protections for elderly persons and disabled adults. Some of its proposals are pretty good, I think, on the whole. One would create a primary language requirement for contracts involving elderly people so that the contracts presented to them must be in the primary language they speak and understand in writing. I think that's generally a positive improvement. However, there's this verification requirement of the person's understanding of documents like powers of attorney, deeds, financial records, and medical records that would include a mandatory video recording of the person getting that explanation from the person they're working with when signing the document. If you all are attorneys, and I believe you all are, this should scare the bejesus out of you because this is an absolute giant arm's reach into the confidential relationships of attorneys and clients. I think there are so many problems with this, I think, nominally good spirited idea that it is not going to get any traction. I do not think that this is going to get anywhere, but it would potentially have some of these other implications that we could see some future bills that are based upon some of these ideas. But that video verification requirement seems like a pretty big death knell for this bill when it reaches committee. So, Nicole, you want to touch on the injunction modification?
Yes. So one of the proposed bills, Senate Bill 32 and 210, it would change the definition of, or expand the definition rather than just repeat violence. It would be repeat or serious violence, and it would, rather than having just, currently it's 2 incidents of violence within a 6-month period, or within 6 months of filing the petition, it would also add, or one act committed by the respondent which causes bodily injury to the petitioner, or a death threat made by the respondent against the petitioner, expanding that definition, potentially making it more feasible for folks to get the protection that they need. And we'll keep an eye on that for now. And it would also expand some of the confidentiality for petitioners before service of process on the respondent. And hopefully we will see some positive movement on this one to allow folks to have more protection in that gap.
Yeah, and you might notice a typo there. Those are a companion set of bills, Senate bill and House bill. I just have it typed to miss that there's 2 Senate bills. There's a House and Senate bill. But there are no co-sponsors, and whether it will make serious traction this turnaround, I'm not sure. But it does seem a part and parcel with another bill that's been proposed we'll talk about in just a minute. I'll touch on SB 48, the reusable tenant screening reports. A similar set of bills were introduced last session, HB 43 and SB 362. They didn't make it very far in the committee process, but these reusable tenant screening reports are designed as a measure of trying to give tenants the ability to access a single report that they can use for 30 days to shop around with landlords who agree to accept them so that they don't have to continue to pay application fee after application fee after application fee. And I think that nominally it's a good idea, and other states have implemented versions of this bill. However, I think I'm a little skeptical about its ultimate success rate, in part because I think it's kind of myopic to assume these application fees are not a profit center for landlords. They are. They're a junk fee. These are not direct pass-through fees. A tenant is not paying an application fee of $85 because that's the cost to access the report from the tenant screening service. It's because there's profit built into that fee. So I think that because this is very much created to be a non-mandatory acceptance, most of the largest multifamily properties are not going to be willing to do this because they make money from forcing people to go through their application process, whether through kickbacks from the screening companies directly or in a direct payment because it's not a direct pass through of the charge. So I would just be, I don't mean to be too cynical about the bill itself, but it's to note that I think there are some fundamental problems that can emerge even if it makes traction this time around. That being said, it is, I think, an important change to hopefully get to a point where tenants don't have to potentially cycle through application fees one after another. The biggest bill I want to highlight for everyone in the public interest law section is an attempt that has multiple co-sponsors and companion bills to create an equivalent of the federally subsidized eviction protection under the Violence Against Women Act for all private residential tenants under Chapter 83 in the state of Florida. So, for those who don't deal with housing or eviction protection, a lot of subsidized housing tenants are protected from being evicted, having their tenancies terminated, or being adversely treated by a landlord because they are a victim of domestic violence, sexual violence, dating violence, or stalking. And unfortunately, those protections have never really extended to private housing in our state. There is a meaningful effort to try to do it for the first time. Now, I'll say that this bill has some warts that I'm not too fond of, one of which is a requirement of producing a very limited set of documents to a landlord to demonstrate that you are actually a victim of violence. And this list is limited to court-ordered injunctions, not petitions, but court-ordered ones. No contact orders entered in criminal cases, letters verifying the victimization from a rape crisis center or from a domestic violence center that's authorized under Chapter 39, or a law enforcement report. There's no self-certification currently in the proposed legislation, which is concerning, but on the whole, it still represents a huge shift in attention. And given the multiple co-sponsors, this hopefully will get a lot of attention. If it does make it out of its first vote in committee, I would really hope that anyone who has the ability to lobby will push to try to get this integrated because this is a huge protection. In part because it allows for the termination of leases by victims without early termination fees or penalties or the damages that would be accessible under Florida statutes for early termination. The sole liability of the tenant requesting to terminate early would be that they would owe the month's rent for the month following the termination date. So if somebody terminated their lease as of today, October 27th, they would still owe the rent for November, but that is the limit of their whole liability for the early termination. And that is a huge move in the right direction. There's also a civil action for failures to change locks upon request of a victim. Unfortunately, there's also a very small cap on the punitive damages that's now in that proposal. It's a cap of $1,000, which is just not a meaningful sanction in any respect. So again, there is some possibility here, though, and I think that there is a core energy behind this bill that could ultimately be a positive one. The final three that we'll talk about, and just briefly, HB 241 would be for landlord obligations and construction contracting. It's a bit of a misleading title because this bill would seek to amend Chapter 83.51 to include air conditioning and cooling equipment as part of a landlord's duty to furnish. And specifically that it has to be capable of cooling the interior to 82 degrees Fahrenheit or less when it is 90 degrees Fahrenheit or higher outside. This would be huge. I don't expect it's going to get traction. But that being said, it's nice to see somebody finally propose it. And it is tied with another kind of nominal bill. It might violate single subject because of that. But it is at least some attempt to push that forward. There's a pair of companion bills regarding water safety requirements for pools. It's a pretty simple one. You got to put up safety devices to protect, mostly kids from entering into bodies of water, whether a pool or a nearby standing body of water. And it would make that a duty of the landlord if a pool or standing body of water is near the residential real property. The final one is just self-storage spaces. This doesn't come up all that much in our work. However, it is a loosening of the requirements of notice. And once again, like with the tenant notification bill, moving towards email as the best method of notice instead of publication. This will streamline and speed up the process for these lien auctions from storage spaces. I highly expect this bill to move. This is, again, brought by the same group that wanted to amend the FCCPA. So I would fully expect this bill to move forward through committee rapidly. So a lot in very short time, and we've left about 5 minutes for questions. So let's try to take care of as many as quickly as we can.
Sorry, I was trying to unmute. All right, I'm gonna drop the CLE code into the chat first while questions come in. The CLE code is 25080808780N. It's 2508780N as in Nancy. So, by the way, if you want to guess, like there were over 1,900 bills filed in 2025. So just kind of breaking down less than a dozen bills here. We probably missed a few. This is why I want to encourage people here, like if whether you're a NACA member, if you're legal aid, using listservs to your advantage and and letting other people in the community know if you stumble upon any bill that's being filed. Also tracking what happens with the bill progress, whether it fails. Kevin pointed out the FCCPA bill, and the great job that Naga and Jala did behind the scenes to make sure that that debt collector language was not added in there. I also have to give a lot of credit on the emo notice bill for landlord tenant to carry fight with Community Justice Project, and also Daniel Cliven with Legal Services of North Florida. He's the one that mentioned that adding that form as an addendum, really giving tenants the option, because the bill that was originally filed was landlord sided. The tenants didn't really have any options at all. So that's it. If anybody wants to raise their hand, I can bring you off mute if you want to comment. If that's a little bit easier than trying to use the Q&A. And Kevin, I'm shocked to hear chapter 83 and the AC. And like, as we approach the colder months, there are provisions for heat, but a lot of people are surprised that there are no provisions for a working AC. So
Yeah, I mean, I
let's
think
see if I see.
the bill goes pretty broad. I mean, it would require the installation of cooling equipment in any property. If a property is zoned historic, it would require only that it be a cooling system consistent with that designation. So, no giant HVAC unit for a beautiful 1909 home that's been renovated and kept up in its historic condition. But an attic fan would be required, and I think that that's really the move, is to try to understand that heat hazards in our state are going to become more and more common. Tampa, stepping over my words, lodged its first 100-degree Fahrenheit day in years back this summer. And I think that it's just an increasing hazard that's going to be present in our state. I'm just dubious it's going to make headway this time. I think eventually it could eventually get traction the further we get along.
So we do have a question in the Q&A. Kevin, somebody commented, I thought that the contract safeguards for the elderly is much needed in Florida, so why didn't you like it?
I agree that some safeguards are important. However, there's two big things to keep in mind. I mean, one, legislators never think about the constitutional problems with what they file. And we do have this contracts clause that allows people to freely enter into contracts. If you create too many guardrails where a person is effectively deprived of entering into needed contracts for necessities, it is facially going to violate the contracts clause, and it's not going to pass muster. So, for example, the translation requirement into primary language, I think that's a winner. That's a huge thing that we would love to see, and to be able to attack contracts as unenforceable because our client could not understand the written document. That's huge. But a verification requirement that requires there be a video of the person being explained the document before they sign it, I mean, that's incredibly intrusive and partially into the confidentiality of those relationships. I mean, every attorney who is attending this meeting, you would be required to do this. That would cover settlement agreements. So, good news, you're recording the meeting you have with your client to sign the confidential settlement agreement to make sure they fully understand everything. And if you don't do it, you can be fined massive amounts of money. The proposal, I think, is just it's well-meaning, but I think that it goes way too far in that direction, and that's why it's not going to gain traction. I do think it's a very needed set of protections, and I think that primary language requirement, maybe that's why they swung for the fences, is they really want that one to stick. Who knows? I can only guess at the introducing parties' motives, but I think that there are some good pieces of the bill, but I think there's a big danger with some of what's presented.
Let's see. I don't see any other questions. I know we're at one, so I wanted to take this opportunity to thank Kevin and Nicole for this amazing presentation. As I said, there were like over 1,900 bills filed. I highly encourage everybody to keep this conversation going. If they stumble upon anything, let us know so we can share information and keep track of the bills as they are filed. And thank you everybody for joining us. With that said, I got the CLE code. Be on the lookout for the email. Kevin and Nicole, any last statements?
Uh, I just appreciate everyone's work in trying to keep track of this. I mean, we're a small group that doesn't have a ton of influence, but we can always use it creatively. We saw it with some of the bills we did this past year. Being able to move for good improvements or to soften bad ones can make a huge, meaningful difference for our clients. So everybody keep tuned to these bills because it makes a huge difference in our lives and what you do.
All right. Well, thank you, everybody. Have a great rest of your day.
Thank you.
Thank you, Jorge, and thank you, everyone.